Now, I want to reference, this is page 71. If you jump ahead to page 87, they reference these numbers again, and you be the judge. I might be reading this wrong, to be honest, but here they say in 2024, DHS identified nearly 77,000 F1 students who haven't spent more than 10 years in the US since SEVIS was implemented. Again, they're identifying that they have the solution, SEVIS, that identifies these specific students they have a problem with. They admit that they have the solution right there already for the problem they're trying to solve for. But here they're saying 77,000 students. In that first footnote, they're saying 2,100. Is there some sort of miscalculation? Why would they calculate something at 2,100 there, 77,000 here? And again, if they identify this one. Now, then the footnote, they say it's based on a student exchange visitor program analysis of data in the student exchange visitor information system and valid as of March 17, 2025. I don't know if we have access to that system. Probably needs an audit, a FOIA, or something like that to see how they came out, that number, who these are. We had the situation a couple of months back where they just canceled a bunch of student visas, H-1B, all this kind of stuff for people who may have had a run at the police, even benign stuff, mistakes and stuff. All these visas were voided, and there's lawsuits happening on that. They have to pull that back. And so I'm guessing this analysis is very similar to that one, especially internally when this two footnotes have such different numbers. That's a huge inconsistency. Let's say 2,100, they said maybe 5,000. Okay, the numbers are different, or they're just only calculating for the first 2000, 2010, doesn't include the next decade. But a jump from 2,100 to 77,000, that's questionable as how the statistics are being used right there. So let's go to page 72 now. How this is interesting enough to keep you engaged in all this. This really goes to like my hypothesis that this situation exists. The 9/11 report reiterated it needed to have a system to track foreign students and place tight controls on student visas. We have the schools, DOS, DSOs, the designated school officials. We have SEVIS. These people, or these students, they're tracked. They've always been tracked. So I'm not sure what their worry is per se about this kind of stuff. It goes into the I visas here about them exploiting the system, which I'm not going to get into here. But they also talk about complying with conditions of their classification. And that's what the big deal they're making. We need to do, and this is the big change, is a person who's here on a student visa needs to do extension of status after 4 years, essentially, if you're going to college. So they have a time to double check you're doing things right. But that's what SEVIS is for. So what's going to happen now is someone who graduates from a 4-year school and then wants to do 1 year of OPT has to not only file the EAD timely, which we'll mess up on all the time, file the wrong I-20, file it before the 30 days are up, put the wrong code number in, all this kind of mess ups. But they also need to file an extension of status from I-539, more filing fees and more errors that could pop up and delays in to be able to get the OPT work authorization. All these kind of problems are going to emerge from here. But they're saying we need to check them up when we file the I-539, so we check on that, which is, you could already check on that. No one's ever stopped you from doing that. That's a term of the visa that could be done. So this is a really misleading aspect there. Frankly, what's going to happen to a lot of people is they may mistakenly work with authorization. They do CPT, and the I-20 says it ends August 31st. They're still working September 1st, 1 day off. That's unauthorized employment. Typically, it's not a problem if they're going to leave or something like that. But now, if they do an I-539 to go to OPT, in that I-539, there's a question, have you worked with authorization? They say no, and then that 1 day gets caught in there in some sort of system, and they're stuck with misrep for a simple mistake that happens pretty frequently. Then here on the bottom of page 72, there's another part that says specifying the effect of departure on F and J visas application. This is an interesting one that we're going to get into more, is that it almost codifies the fact that POSA-BAG, period of authorized stay authorized by Attorney General of the United States, that may be considered authorized period of stay. That I did another special episode where I interviewed Samir Kedeker about this, where if you have a extension of status, change of status, even just in case pending, once your underlying status ends, you're in an authorized period of stay, so you don't accumulate unlawful presence stays. That's a whole technical conversation there. On our free community page for immigration lawyers or just lawyers, we have a breakdown of a 3 to 10 year bar, all that stuff. You can watch their video. But what we see is that they're specifically saying that once you file the extension of status, even though the underlying F1's done, by that point, your I-94 is expired with this new system, you're authorized to stay here. They're saying it specifically. So if they're saying it in this kind of context, this is one of those things that can be used in others and say, why are you NTAing me? You're explicitly now saying this is a status and you shouldn't be doing that. It says allowing F non-immigrants to timely file EOS applications, it specifies Fs, but to remain pending after their admission period has expired to receive automatic extension of the current authorization for on-campus office. This is about work authorization, but it goes in more details. I'll get to it in the next sections that come into it. But that's an interesting thing that came up there.